Good afternoon, everyone. My name is John Gallo. I'm the CEO and Executive Director of Legal Aid Chicago. Welcome to our 7th session of our series called Finding Solutions Legal Aid for Our Most Vulnerable Populations. Today's session will focus on families involved in the child welfare system and how legal aid can help those families. So to get started, I'm going to turn it over to our host for today's session, Tim Kincaid. Tim is a partner at Winston & Strawn, which is one of our longtime law firm partners, and I'll turn it over to Tim.
Thanks, John. Winston & Strawn has a long history with Legal Aid Chicago, both through support and partnership. The work performed by the incredible attorneys and staff members provide a path and a connection to the basic needs and protections that all people should have access to without impediment. Legal Aid Chicago is an organization for our most vulnerable fellow Americans that seeks to neutralize gaps, resource gaps, education gaps, and economic gaps. It provides services and access that we too frequently take for granted. And its mission and its relentless pursuit of equal justice resonates with me and Winston & Strawn in a very powerful way. It makes us proud to support and be affiliated with such a critical organization that is doing the work to make our fundamental rights the rights of all, not just the rights of a select few. The work is more than meaningful, it is essential. And it is no more vital to anyone than to our children, which makes me even more honored to introduce our amazing panelists for today's seminar. I have the pleasure to introduce to you Melissa Stas, a supervisory attorney in the Children and Families Practice Group at Legal Aid Chicago, Darren Harris, the program director at Family Focus LAWNDALE, and Jamie Schulte, a supervisory attorney in the Children and Families Practice Group at Legal Aid Chicago. With that, I turn it over to Melissa.
Hello, everyone. So when people think of the child welfare system, two thoughts commonly come to mind. First, that the child welfare system refers to kids being in foster care. And second, that kids in the child welfare system have been horribly abused. And while both of these things are a part of the child welfare system, they are actually a very small piece of the whole story. The child welfare system is much more vast than most people imagine. In fiscal year 2019, there were approximately 87,000 investigations, and only 6,600 of those resulted in DCFS taking protective custody, which would mean that the kids then enter care, typically known as foster care. So that's less than 10% of all investigations. Also, of those 87,000 investigations, the lion's share, about 85%, were regarding neglect allegations, not claims of serious physical abuse or injury. And unfortunately, the child welfare system has a long history of conflating poverty with neglect, meaning that families that have limited economic means, the families that Legal Aid Chicago helps, are at a much greater risk of coming under the scrutiny of the child welfare system and then experiencing adverse outcomes. And this is a trend that we not only see in our day-to-day practice at Legal Aid Chicago, but it's also been recently recognized by the Children's Bureau. The Children's Bureau is a subdivision of the Federal Department of Health and Human Services, and it's the federal agency that oversees state child welfare agencies. And some of the recent policy positions the Children's Bureau has issued on this topic of confusing poverty for child neglect and for overreaching by the child welfare system when there are claims of neglect as opposed to serious abuse have been included in the Children's Bureau Express publication that we distributed yesterday. Next slide. So Illinois' child welfare system is operated under the Department of Children and Family Services. That's probably DCFS is an acronym that most people are familiar with. And since 1974, every state is required to have a central child abuse hotline. And that's how every investigation or DCFS intervention with a family in Illinois starts with a call to the hotline. And the hotline is a funding requirement pursuant to federal legislation under CAPTA, the Child Abuse Prevention and Treatment Act. In Illinois, DCFS operates this hotline through what's called the State Central Register. And then the existence of the hotline and the authority to then investigate those calls is governed under the state statutory framework, the Abused and Neglected Child Reporting Act, or ANCRA. And ANCRA is also where we find the mandated reporting requirements, which in Illinois, as in most states, are very, very broad, both in terms of who is considered a mandated reporter. That would be the type of professionals you would think of as coming into contact with kids on a regular basis, like law enforcement, doctors, teachers, but also positions that you wouldn't usually think of, like funeral home directors and acupuncturists. It's really a list as long as your arm of everybody who is required to report. And then it's also broad in terms of what is required to be reported. And the standard under ANCRA is that a professional in one of these fields is required to make a report when a child known to them in a professional capacity, and they have reasonable cause to believe that that child may be abused or neglected. It's very broad. It's framed in sort of speculative conditions, and the result is that the system receives a flood of calls from people who have interpreted that they have a required legal mandate to call, and it does overload the system and leads to this huge number of neglect allegations that we've discussed or that I mentioned at the top. So when an investigation starts, hotline call is received, the assigned investigator has two primary determinations they need to make. The very first one they need to make right away, and that's a safety assessment of the child. And I'm going to talk about that in just a few minutes. And then in terms of, as the investigation proceeds, what is the sort of product of that investigation is the investigative outcome. They need to decide, was the child abused or neglected? Or are we going to unfound this allegation, or are we going to indicate it? In terms of reaching that determination, the definitions are, investigators are supposed to be guided by the statutory definitions of abused child and neglected child that are found in the enabling statute, the Abused and Neglected Child Reporting Act. And then DCFS has also promulgated their own administrative rules that create subcategories of abuse and neglect through an enumerated allegation system. And by enumerated, I mean that each subcategory of abuse or neglect is assigned its own number. So some examples would be that allegation number 9 would mean there's a suspicion of a bone fracture caused by abuse. Allegation number 59 would mean a suspicion that a bone fracture was caused by neglect. And the difference between abuse and neglect, according to the statutory legal standards, is that abuse is non-accidental injury, and neglect is injury or placing a child at risk through blatant disregard. And there's lots of nuance and case law about what blatant disregard means, and the statute sets out a pretty specific definition, but that's probably beyond the scope of this presentation. There are other allegations that are pure neglect allegations, and that would include such as allegation number 74, inadequate supervision, or allegation number 77, inadequate. Allegation that we very typically see is allegation number 60, environment injurious, which is historically amorphous concept that's sort of used as a catch-all when one of the other allegations doesn't really quite fit. So at the conclusion of the investigation, the investigator and his or her supervisor make a determination as to whether to indicate or unfound the report. And in order to indicate, it's a pretty low burden of proof. The standard is there credible evidence to believe that abuse or neglect has occurred and that the person under investigation was responsible? This is credible evidence is much lower than preponderance. It's probably something akin to probable cause. And as a result of some federal litigation from some years back, Dupuy versus Samuels, that's D-U-P-U-Y, there is a requirement that it can't just be if there's some credible evidence and looking only at the inculpatory evidence. DCFS does have an affirmative duty to collect and consider exculpatory evidence as well. So there is supposed to be a weighing of the evidence, and that the extent to which that actually takes place in practice is highly variable according to the investigator that's assigned. So if DCFS decides that yes, we think there's credible evidence here to believe that this child was neglected and that the parent was responsible for that neglect, the result is that the parent's name is placed on the state central register as a perpetrator of neglect or abuse, according to what allegation is being alleged. And this is effectively an administrative determination of guilt, and it's made before the person who's under investigation has any opportunity to present their own information to a neutral decision maker. Most people are only granted post-deprivation process, meaning that they only get a chance to challenge the indicated finding after the injury of having their name placed on the state central register has already occurred. And the impact of having someone's name on the state central register can be really far-ranging. It is a semi-private database, so not everybody can access it, but it certainly operates as an employment blacklist for workers in certain fields. That would mean teachers, therapists, daycare workers, home daycare owners. These are all people that would immediately be barred from continuing in their field. But it also includes workers that maybe don't work directly with children, but they work in a field that does require them to have a clear background check. So one example would be paramedics. Paramedics don't work the majority of time with kids, but paramedics have to clear a DCFS background check. A lot of our clients might work as home health aid workers. Home health aid workers have to clear a DCFS background check. An indicated finding can also be a bar to being a foster parent or adopting. And the way that this can sort of destabilize low-income families is that if a person's adult child has their own child that then enters the foster care system, the grandparent can't serve as a kinship care provider if they have an old indicated finding on their record. And then a final impact that we see every day is that once someone has one indicated finding on their record, it can really be a snowball effect. And they are at greater and greater risk of future indicated findings, and then ultimately greater risk of having their children taken into protective custody based on future hotline calls. So at Legal Aid Chicago, the sort of advocacy we do is that we do provide advocacy during an investigation in order to try and fend off an indicated finding if we think that the allegation just isn't supported by objective evidence. And we also represent people in appeals from an indicated finding. So as I mentioned, it's only after DCFS has entered an indicated finding on the state central register that someone has the opportunity to challenge the evidence in front of a neutral decision maker. And this occurs through a hearing proceeding within DCFS's Administrative Hearings Unit. And for the first time, DCFS, who will be represented by an attorney, must prove that a preponderance of the evidence supports the allegation. The case is heard by an administrative law judge within DCFS's own hearings unit. It's usually a half to full day hearing. It might be a 2 or 3 day hearing if it's a super complex case, but there are witnesses who give testimony under oath, there are exhibits, and there's oral argument. It's sort of like a mini trial. And about 6 weeks after the hearing concludes, the person who has appealed their indicated finding receives a written decision notifying them as to whether their request to expunge the indicated finding is being accepted or denied. If it's accepted, case done. All right, name is cleared from the state central register. If their request is denied, then that individual does have the right to seek further review by the circuit court in the Chancery Division, and that's pursuant to the Administrative Review Act. And we do sometimes represent individuals in those proceedings as well. And then if you lose there, you can go to the appellate court and potentially all the way up to the Supreme Court. And there have been cases that the Illinois Supreme Court has decided that originally started as a DCFS administrative hearing. So I'm going to describe a few cases that illustrate some of the issues we encounter while representing parents who are finding themselves ensnared by the child welfare system, especially at the front end. Jamie's going to be talking a little bit about what it looks like when juvenile court cases actually started. So our client Yasmin is the mother to 4 children, 3 boys and a daughter. And the daughter is the youngest, and she was about 7 years old at the time the DCFS investigation started. Leading up to the investigation, Yasmin and her kids were living with her longtime partner, Jonathan, who's also the father to the 4 kids, and his drinking had begun to increase, and he was starting to drink excessively, and this was leading to some verbally abusive behavior towards Yasmin and just some generally erratic behavior. And as a result, she recognized that this was problematic, and she sought out therapy services for herself and the kids. And during one session with a therapist early on, the daughter made a vague statement about seeing her dad hit her mom with a towel. And due to the therapist's interpretation of her obligations under the mandated reporting statute, she contacted the hotline. And then after an investigation, DCFS indicated a finding against not only Jonathan, but also Yasmin, faulting Yasmin for allegedly exposing her children to domestic violence. So we're representing Yasmin in her appeal of this indicated finding. It hasn't gone to hearing yet, but there are several aspects of DCFS's handling of this case that I think are troubling and worth mentioning. First, Yasmin had recognized that there were issues in the home life that needed to be improved, and she had sought out some steps to try and make those improvements by engaging in therapy for herself and the kids. And as a direct result of that, she ended up getting an indicated finding against her. This provides a very clear disincentive for her to be candid and expose her children to therapy in the future. And the other very troubling aspect is that Yasmin was employed as she had been employed for years and years as a daycare worker. And as a result of the indicated findings, she lost her job. The irony is that she very much wants to separate from Jonathan, but she now lacks the economic means to do so. So in effect, DCFS's response to the problem is only serving to prolong the problem. Another client is Melanie. And Melanie and her 10-year-old daughter lived in subsidized housing, and the rental house that they were living in was very decrepit. It had a lot of issues that she herself would not be able to address, such as a broken stove, a clogged tub. The front porch had crumbling stairs. There were broken outlets. These are structural issues with the house that first she wasn't responsible for, the landlord was, but even if she wanted to address these issues, she couldn't because she simply didn't have the money to do so. She made repeated entreaties to the landlord to make the necessary repairs. The landlord refused. So Melanie started the months-long process of obtaining moving papers from the Public Housing Authority. And because she was a voucher holder, she couldn't just leave right away. She had to go through a process in order to get her transfer papers approved. So while she was waiting for authorization to move, someone called DCFS. And after an investigation, they indicated her for allegation 77, inadequate shelter. And what's particularly notable about this case is that we, Legal Aid Chicago attorneys, represented Melanie at the administrative hearing and made all the arguments about why Melanie should not be held responsible for these needed repairs and how she was taking steps to try and extricate herself and her daughter from this living situation. And despite all those arguments and despite representation by very knowledgeable counsel, the administrative law judge did not approve expunging the indicated finding and instead sustained the indicated finding. And we then had to represent Melanie in seeking further review in the circuit court. And after a very labor-intensive briefing schedule, we were finally able to clear her name. But what's clear is that Melanie never could have achieved this outcome without attorneys who had subject matter expertise in this field. So as I mentioned earlier at the very outset, as I mentioned earlier at the top of the presentation, at the very outset of every investigation, DCFS has to make a safety determination. And if they conclude that a child is unsafe, the investigator has two choices. They can either take protective custody, meaning placing the children in foster care, which could be with relatives, and then they are required to bring the case before a judge within 48 hours. Jamie's going to talk about that process in just a bit. As an alternative to protective custody in court, the investigator could decide to implement what's called a safety plan with the family. A safety plan is usually a set of conditions or requirements under which the family is expected to reside for a certain period of time. Usually the duration of the investigation. It can oftentimes go past that. It's a very murky area of law anyway. But usually it means the parent can't have any unsupervised contact with the kids. And often this means the kids leaving the home. So there's a huge disconnect between how safety plans are supposed to be utilized in Illinois and how they actually play out in real life. They're supposed to be used only when the investigator would otherwise have grounds to take protective custody. So that would mean probable cause to believe abuse or neglect has happened, and there are exigent circumstances placing the child's life or limb at immediate risk, which requires there's imminent harm requiring immediate response. But oftentimes the investigator doesn't have grounds for protective custody and will still use the threat of foster care as a way to coerce a parent to agree to the safety plan conditions. Secondly, the parent is supposed to have a say over the terms, over, well, what if we did it this way? What if my mom came to live with us? Or, oh, we really don't like, the paternal grandmother is not a supportive person. We'd rather that the kids go stay with a different relative. But it's hardly ever the case that the investigator is going to take the parent's feedback about what sort of circumstances they want into consideration and will instead dictate the terms of the safety plan to the parents. And then finally, safety plans by definition are supposed to be short-term and time limited, but more often than not, they are usually indefinite. Oftentimes parents won't even receive the written safety plan as a copy for them to keep. There's no clear criteria for ending the safety plan, and they continue for an indeterminate amount of time. So these features of a safety plan are inherently problematic because of how traumatic and disruptive safety plans are for families, including the kids, and particularly when they linger on and on and on with no clear end in sight. And safety plans do implicate fundamental constitutional rights because they're interfering with family integrity. So this will trigger rights under the 14th Amendment procedural due process and substantive due process clause. And also Fourth Amendment seizure standards as well if the children are being removed from the home. And there is a whole line of civil rights case law on the use of safety plans in Illinois and in other states. It's a topic that is being subject to much and much more scholarship and scrutiny by professors and legal scholars in the field. It's been referred to as hidden foster care. But that all is beyond the scope of this presentation, but I wanted to bring the concept of safety plans sort of to your awareness. Next slide. So over the past year, Legal Aid Chicago has been working to implement a strategy for promoting family preservation that taps into our unique position as being a multi-issue legal agency. As if you've attended any of the other series, you know that we have attorneys who have expertise in just a wide variety of fields and areas of law. And oftentimes there are underlying civil legal needs that are causing a family to be more vulnerable to unhelpful intervention by the child welfare system. And our goal is to help families address those needs upstream or before DCFS intervention snowballs to a point where the family has become just deeply mired in the process. And it can be much more difficult to sort of get out from underneath the weight of the child welfare system. So the cases I've described have highlighted some of these presenting issues, such as orders of protection or housing advocacy. But before I turn it over to Darren, who's going to be talking about the services that his agency provides for DCFS involved families, I want to describe just one more case that really encapsulates all of the complicated legal issues that could be causing a parent to be particularly vulnerable to DCFS intervention. So Corinne shares custody of her 3 daughters with her ex-husband, and she works as a licensed clinical social worker providing therapeutic services for kids. This past December, Corinne sought out mental health services for herself when she realized that the medication that she had been taking for a long, long time to effectively treat her own diagnosis of bipolar disorder was no longer being quite as effective as it had been before. And during her mental health intake, she endeavored to be very candid about all the issues that were going on so that she could receive the best possible care. And she did disclose that her fiance had become physically abusive on occasion, and that during this relationship, he had also sort of sucked her into his own addiction to meth, and she had developed a dependency on methamphetamine. There was never any evidence that any of the domestic violence had occurred in front of the kids. And in fact, when interviewed, all the kids clearly denied ever witnessing any abuse. And there was never any evidence that Corinne had ever used any illicit substances while caring for her kids. Like I said, she shared custody with her ex-husband. But most importantly, like I said, Corinne was making these disclosures in an effort to be candid and open and forthright so that she could get the services she needed to be the best mom that she could be. So when she came to our agency, her presenting legal issue was this pending DCFS investigation, which frankly had the just a looming threat of destroying her career. But it became apparent to us that there were a host of other legal issues she needed to address in order to really successfully defend herself from a claim of child neglect and to provide, to set herself up for future long-term stability. So we represented Corinne in obtaining an order of protection against her abusive fiance. She had been living with her fiance, and attorneys with our housing practice group helped her break her lease, and this is through a provision in the Safe Homes Act that permits a domestic violence survivor to break a lease without penalty. Then when Corinne tried to secure a new lease, it was discovered that she had a prior rent debt on her credit report. So attorneys with our consumer practice group helped her get that debt canceled. And we also provided ongoing social work support through our client support services, which really helped her in priority setting during a really stressful and confusing time. And then during all of this upheaval, Corinne was under this constant threat of a DCFS indicated finding. And the investigator and her supervisor intended to indicate a finding against Corinne. That was what they thought should happen. And through our advocacy, we were able to convince a higher level administrator with DCFS that they simply did not have sufficient evidence to sustain the indicated finding. And we were able to prevent that devastating impact. So I'm going to turn this over to Darren. But before I do so, we're going to share the CLE code for those who will be seeking credit. You'll enter this code into the Google form that's linked in the chat, and that code number is 232160. Again, 232160, and then I will give you Darren Harris.
Thank you so much, Melissa. And thank you, Legal Aid Chicago, for allowing me to talk about the work that Family Focus does and the partnership that we will be piloting that started this spring. So my name is Darren Harris, and I'm the Program and Center Director at Family Focus LAWNDALE. Next slide, Justin. Family Focus has been around for 45 years. A lot of what we do, a core of what we do, is early childhood development. supplemented by youth development services and family support services. Excuse me, I'm sorry. We recently just went through a merger with Chicago Child Care Society, who does a lot of the same work that we do with regards to early childhood development, but they do a lot of early Head Start center-based work. And we are pleased to have a new CEO by the name of Dara Munson. We can go to the next slide, Justin. What I want to talk about first is our Family Advocacy Center programs. And because that's a bigger program than our Fatherhood Initiative Program, number one, but two, that's kind of the core of what the partnership looks like. So we provide comprehensive services and resources for families involved in the child welfare system. What that looks like is that we have families that come into our that are referred, by child welfare workers, caseworkers, case managers for POS agencies and DCFS for a number of different reasons. A lot of them, 95% of them are DCFS involved in some capacity. Melissa touched on this earlier with those who have indicated cases when the child has been removed from the home, and then there's those families who are being investigated, and then those families who have intact families who are unfounded. And so what happens with that is that we receive a 507 referral form, which is a DCFS generated form to indicate what type of services that the case manager is looking for those participants. 90% of the time is for parental education. We do parental education through parenting classes. We use a evidence-based curriculum, whether it's through our fatherhood program or our FAC program. And then we also do individual parent coaching for those who need, who may have completed parenting classes, but need some more intensive parental education. So we do that one-on-one parenting coaching with them. We can do that in a number of different ways. Right now we're working virtually. And so we have to do it, one-on-one virtually, but we've also in the past done it doing parent-child visits for those parents who have had their children removed from the home. We also do trauma counseling at Family Focus, as well as external referrals. And that's kind of how the partnership with Legal Aid Chicago is going to work. And we also do DV external referrals, as well as employment referrals. And so lastly, we could go back to the last slide, Justin, because I want to touch on the Fatherhood Initiative Program. We also have a Fatherhood Initiative Program. We've been doing that for about 20 years. We provide parenting classes, case management, and other support services for fathers. And what's important about this work is that a lot of times fathers don't have the same considerations that mothers do, even when the non-custodial parent. And I want to touch on that really quickly, is that what happens is that the mom will have a call or will be founded for abuse and neglect. And instead of automatically having the child or children reside with the father, with the other biological parent, DCFS will place the child with the maternal grandmother, maternal aunt, maternal sister, or whoever, or even sometimes even the paternal aunt or uncle or grandparent, without taking into consideration that the father could be the parent. And so that's where some of the legal supports that the fathers that we work with come into play. And so I just really wanted to quickly touch on that just understand that sometimes the fathers aren't given the same consideration as a parent, even when they haven't caused the abuse or neglect. Okay, you can go to the next slide, Justin. Thank you. And so what this is going to look like, we were approached by Legal Aid Chicago to partner to do a pilot to provide some legal support for our participants that we serve who are DCFS involved or in danger of being DCFS involved, and Melissa touched on that earlier. And so we're going to do that at two different sites. The first pilot that Legal Aid Chicago did with a Family Advocacy Center program was at SOS Villages, and we're the kind of second iteration of that. And so Our two partner sites will be Family Focus Lawndale, where I'm the program and center director at, and then also at Family Focus Inglewood, which serves Inglewood and the surrounding zip codes of Auburn, Gresham, and some of the other further south side communities and neighborhoods. And so what the partnership is going to look like is that our family advocate workers and our case managers are going to identify participants who need legal support. They're going to work with the center directors, which is myself, along with Carrie Brown at Family Focus Inglewood, and we'll kind of staff the case to see if it's appropriate to send over to Legal Aid Chicago. And once it's been determined that there's a need for some type of legal support from Legal Aid Chicago, I will contact a representative at Legal Aid Chicago to kind of talk about, what, fill out the paperwork and the intake forms and talk about what the needs of the participants are. And then lastly, Legal Aid Chicago will follow up and contact the participant who is in need of those legal services. Now, there's some limitations about how we can do follow-up and kind of speak with each other because of confidentiality, but there are some general updates to say, okay, we've made contact, we will move forward with this case. Oh, we weren't able to make contact, and we're going to have to move in a different direction. And so that's just generally just a quick kind of synopsis of how the relationship started and what we're looking to do and how we're looking to support our participants. So next, I'm going to swing it over to Jamie.
Great, thanks so much, Darren. We're really excited to be starting this partnership with Family Focus and with Darren to make sure that we're really better able to work within the communities and make sure that we're getting the clients that really need these services, as Melissa's talked about. So now we're going to take a slight shift, and I'm going to talk a little bit about some overall issues with the system, and then focus really on the work that we do for families that are involved with juvenile court. So one thing that's important to keep in mind is, in addition to the conflation of poverty with neglect, that means a lot of the clients that Legal Aid Chicago serves are disproportionately impacted by the child welfare system, there's also extreme disproportionality in terms of race. So in Cook County, over 70% of the youth in care, which is the term used under the statute for all kids that are in out-of-home placement, so placed with relatives, placed with stranger foster parents, and residential homes, over 70% of those youth are Black, despite the fact that Black people account for less than 24% of the population of Cook County. And this is not just a local issue. Across the nation, there's an extreme amount of disproportionality based on race. Native Americans, for example, are another group that are highly overrepresented in the child welfare system. There's a lot of different arguments or theories behind why that's the case. For example, the conflation of poverty with neglect and the systemic racism within our country, redlining, things like that lead to poor housing conditions for a lot of racial minorities can mean that there are circumstances that are more likely to lead them into the system. And there's also belief and concern of bias within the child welfare system itself. Now, there's the overrepresentation includes all stages of the process. So as Melissa talked about, the mandated reporting or even non-mandated reporters who make hotline calls, all the way through children being removed from care and through how quickly and if children return to their parents. There's a very pronounced overrepresentation in out-of-home placement. And studies have shown that white families are more likely to receive offers of in-home based services, short of removing the child from the home, than Black families are to receive. So because of these extreme disproportionalities, it makes the urgency of kind of systemic reform as well as strong individual representation, as Melissa spoke about, very critical. So Melissa spoke about hotline calls, investigations, indicated reports. And as she mentioned, DCFS investigators then make a determination of whether or not they think they need to take protective custody. So if a DCFS investigator believes that they must take protective custody because there's an urgent and immediate need, the child's immediate safety is at risk, that child can only be in custody for up to 48 hours, not including weekends and holidays, before the case is brought in front of a judge. So the DCFS investigator takes that case that they're concerned about to the state's attorney, and the state's attorney does a screening process to assess whether or not it's appropriate to move to court involvement. If the state's attorney determines that there is an appropriate basis, then a temporary custody hearing is held. A temporary custody, there are three things that the judge needs to determine. One is that there's probable cause to believe that the kid or the child or children was abused, neglected, or dependent. And dependent, we've not spoke as much on today, but has to do with the fact that not because of any misdoings by the parent, but the parent is unable to care for the children due to any number of factors that they don't hold the parent to be responsible for. The court also has to find if there's urgent and immediate necessity for the child to be removed from the home. And lastly, the court must determine if reasonable efforts on the part of DCFS could potentially prevent the need for removal from the home or prevent the need from court involvement. If the court finds all three of these things, then temporary custody is taken of the child and the case remains involved in the court. The other options are that the court finds there isn't probable cause, the case is completely dismissed. This is pretty rare in Cook County, and I believe more broadly as well. Or the court could find there is probable cause to believe there's abuse or neglect, but we don't believe there's urgent immediate necessity or reasonable efforts could mitigate the need for removal of the child. And so an order of protection may be put in place where the child is able to remain with the parent under certain circumstances and the case remains within the court. After that stage goes as kind of the next stages of court that I'm only going to touch on pretty briefly just for the sake of time. But an adjudication involves a court determination of whether or not the child was in fact abused, neglected, or is dependent. And then disposition after this adjudication decision regarding whether the child was abused, neglected, or dependent has to do with whether the parent is fit, willing, and able to care for the child. If and when that happens, the child will be returned home to the parents and reunification can happen. Other outcomes can involve children aging out of care. This is pretty common for kids that come in during high school age, or a guardianship done with frequently a family relative, or termination of parental rights, which cuts off the child's right to ever have a relationship with the parent, legal right. Sometimes it happens despite that, but the legal rights that children have to their parents and the parents have to their children. Now, in the state of Illinois, there's a right to an attorney in this process. So parents do get appointed an attorney at the temporary custody hearing stage. So we at Legal Aid Chicago work pretty collaboratively with the Cook County Public Defender, who's appointed to most of these cases. And we also work with other advocates in this area. One of the major things that we do is we can help connect clients to civil legal services, which are all the pieces that Melissa spoke on earlier about how significant it can be for families to get orders of protection, housing assistance, public benefits in order to move towards reunification and make sure that their families can reconnect. We also do some individual representation, and that will frequently happen if we are working with families in a number of civil legal services, and it makes more sense to kind of consolidate their services with our organization in terms of the representation in juvenile court as well, or certain cases where we feel like the cases are really emblematic or important in the issues that Legal Aid Chicago is working on more broadly. So particularly pure poverty cases or cases that are involving domestic violence services. And then a third way that we've collaborated is with amicus brief. So actually just accepted yesterday was an amicus brief that we worked on behalf of a parent who was represented by the public defender's office, is currently represented by the public defender's office. That parent had received an unfavorable outcome in the juvenile court trial level. The court found one child abused and neglected and the other children neglected. The appellate court overturned that determination and found that the neglect and abuse findings were not supported. And then the Office of the Public Guardian and the state's attorney appealed that decision to the Illinois Supreme Court, and they granted cert of the case. So our brief spoke particularly on a lot of the issues we're talking about today, which is, addressing the fact of the kind of the more amorphous nature of neglect in particular, and the importance of looking carefully at these cases because of the fact that there is, a lot of racial bias that impacts or infiltrates the system in different ways. The fact that people who are poor are often brought in for things that are considered neglect, but really may just be poverty. And also addressing the most recent data and research that really supports how traumatic and troublesome removing children from their parents can be. So that when we're making these decisions, when we're determining what is in the best interest of children, that we really do need to consider that going into foster care, being involved in the system, creates a lot of harms to children in many circumstances. So while there are, certain limited cases where that is necessary and makes sense and must occur, it really needs to be looked at very carefully, particularly in cases involving neglect, because of that harm that we know often comes along with that. So Priscilla's story is one example of a case that we're working on with a juvenile court involved parent. So Priscilla's case came to the attention of DCFS because her then boyfriend, who was also the father of her youngest of her 3 children and was living with the family, was accused of sexually abusing her oldest daughter. Now, when Priscilla learned of this, she was shocked, as we would hope. She had no expectation or belief that this was happening to her daughter, or hopefully she wouldn't be allowing that to happen. So this was a complete shock to her. Now, as soon as DCFS became involved, as soon as she heard of this allegation, she never denied that anything had happened. She didn't take a negative position towards her daughter, say that her daughter had made things up. She worked with a safety plan and had all 3 children staying with a relative and didn't allow any contact with the then boyfriend. But Priscilla did not immediately leave him. As Melissa spoke on, a lot of our clients don't really have the economic position or ability to immediately go stay in a hotel or immediately move out in that kind of situation. Priscilla had also experienced domestic violence at the hands of this individual, and the power controls and dynamics can make that situation really complicated, and what's really possible for parents as well as what's in the best interest of the family overall can be a little bit less obvious than originally meets the eye. So because of this incident, the case comes to DCFS attention, all the children are removed and the juvenile court process is begun. Now, Priscilla came to us in regards to an order of protection against her then boyfriend. And as we worked with her and worked on the case, we determined along with Priscilla to take her case in juvenile court as well. A big piece of our representation to date has been involved getting unsupervised day visits. So most cases when they come into court, the vast majority, regardless of what the allegations are, start with supervised visits only for parents, meaning that even if the allegation was solely that the house was in poor condition, the parent is not able to be alone with the children, even in a public place, without specified supervisors being present for that. So that had been the case for Priscilla for over a year, implicated particularly because of COVID that actually prevented parents from seeing their children at all for an extended period of time. And we were able to advocate and get her those unsupervised day visits. And we've continued to push and work to move forward her case and kind of see the important needs for the family to work towards reunification, to work towards conclusion of the case. And our advocacy in that area continues. So one thing that I think makes Legal Aid Chicago particularly unique in terms of our involvement with juvenile court involved families is in addition to representing parents and caregivers in the indicated finding process and in juvenile court itself, we also represent kids in foster care within their education matters. So again, youth in care is the term used for both kids that are within traditional foster care as well as in shelters and with relative placements, all children who are removed from the primary care of their parents. This is very critical work because we know that there are significant educational challenges for youth in care. High school mobility, meaning the number and frequency with which children are switched schools. Data shows that for 17 and 18-year-old children in foster care, 34% of them have experienced 5 or more school changes. And we know that school mobility is related to lower academic achievement, missed school time, and a lot of other kind of negative ramifications for kids. There's also missed school time even outside of that mobility. So for services involving with the court or the process even of moving between homes and foster care changes, and that can also negatively impact children. Impacts of trauma exposure also create a lot of difficulties for kids in school. So sometimes that's the trauma they've experienced prior to coming into care, and sometimes it's even just a trauma of entering the system, entering this process, moving to an adult that they've never met, not only leaving their parents, but also sometimes their siblings and their neighbors and their church and their school and their friends. And that trauma can really impact the way that children act in school and hurt them academically, as well as risk disciplinary issues. And there's also additional challenges for youth with disabilities. There's a much higher rate of kids receiving special education services under individualized education programs for kids in care compared to the general population. And again, particularly with school moves, this can create particularly difficulties for kids with disabilities because their records don't always go right away. And this new school may not realize the disability that the child is facing or what services they need. And there can be gaps in those services. And so for all of those complicating factors that youth deal with, unfortunately, data indicates that there are poor educational outcomes. So higher rates of suspensions and expulsions. The exact numbers on this really vary depending on what studies you're looking at, but generally speaking, it's 2 times or greater chance that you will experience an out-of-school suspension for kids who are in care. There's also lower academic achievement, higher rates of retention. In repeating a grade, retention is correlated with less likelihood of graduating at all and less likelihood of graduating on time. And that's borne out in the fact that youth in care have much lower rates of high school graduation. So according to one study, 65% of youth in care completed high school by the age of 21, and that's compared to 86% of youth overall between the ages of 18 and 24. So since we know kids in care are experiencing these difficult challenges and problematic outcomes, what does Legal Aid Chicago do about that? Next slide, please. So our work with youth in care covers a really broad variety of work for kids actually in pre-K through 12th grade. So I've highlighted here some of the most common things that we work in. ESSA, the Every Student Succeeds Act, has a great deal of different components to it, but the significant one for youth in care is a right to stay in your school of origin when you enter care or when you're moved placements. And that includes the school district and the child welfare system collaboratively working to pay for transportation costs if transportation is an issue that prevents you from staying in your home school. And while schools are generally very aware of this, they often don't want to do it. They don't want to pay for the busing or deal with the other kind of complications of kids living in one district and attending school in the other. So we work to help enforce these rights so children don't have as much school mobility and get greater consistency. As I mentioned, there's also a higher rate of students with disabilities in foster care, and we represent students to help ensure that they get a free, appropriate public education as required by law. This can involve advocacy at IEP meetings, administrative due process cases, which I'll speak more on in a second, and more informal advocacy to make sure that records are passed, that they get their appropriate services. We also help ensure the due process rights of students in school discipline matters, which is protected both by state and federal law to address the overrepresentation in out-of-school discipline for kids who are in care, and a variety of other matters, including Title IX. Title IX is the federal civil rights law that prevents discrimination on the basis of sex in schools that receive public funding or any education program that receives public funding. We represent students both who are survivors of sexual-based violence, whether within school or out of school, that have implications for their ability to function in school, as well as youth who are accused in these kind of circumstances and making sure that their rights are protected as well. So Michael's story, I think, is a good example because like most of our students or our clients, he's experienced a variety of different legal issues in regards to schooling. So when we met Michael, he was about 16 and a half years old. He had had an IEP for a long time that included noting he had some learning issues, but he was largely treated as a behavior problem. His case came to Legal Aid Chicago because of the fact that he was repeatedly being suspended and the school was now talking about expelling him. And under law in Illinois, if a student is expelled from school, they can be prohibited from attending any public school or private school in the state of Illinois for up to 2 school years. So all kids can be given alternative schools, they don't need to be. So many children are sent home entirely for up to 2 school years. So we got involved with Michael to help address these discipline problems, but there are connected rights when kids have an IEP, as Michael did have. We advocated for his needs and helped get him into a specialized school for students with disabilities. And within that school, there was some additional evaluation and testing we pushed on, and it was determined that Michael had an unidentified language processing disorder that the school had failed to evaluate from kindergarten up until he was 16 and a half. So this disorder meant it was both harder for him to receive a receptive language disorder, meaning harder for him to process and understand things he was hearing and learning, and also an expressive language disorder, which means it was harder for him to kind of pull words from his mind to be able to express the things that he was learning. Not surprisingly, kids that have undiagnosed needs like this will often demonstrate in behavioral ways because they don't really know what's going on. They don't really know how to function within school. So in Michael's case, we brought an administrative due process case under the Individuals with Disabilities Education Act, and we were able through that process to get him a very substantial amount of compensatory education services, which means the school district is required to pay for services to help get the child to where they should be had they been receiving the appropriate services all along. And I think another interesting piece of Michael's story is that even within the course of when we filed our due process case until the decision came out, which I want to say was around 6 months now, Within that period of time, he had 3 different placements and 3 different educational rights holders. So Michael had been in the home of one foster parent when that case began. Michael was arrested for something that happened outside of school. He was brought into the juvenile detention center, and his foster parent said, "You can't come back." So he no longer had that foster parent. He was in a temporary detention center placement and had a volunteer educational surrogate parent who was appointed to represent him. He then is released from the detention center, but because the former foster placement is no longer viable, he gets a new foster parent, and so has yet an additional educational rights holder in this case. So one of the things that I think Legal Aid Chicago really is able to provide is that at least through the course of a case that we're representing a kid on an education matter, we're able to provide some of that consistency and stability in terms of knowledge of the kid's needs when a lot of other things around them may be changing and may be much more unstable. So I think Michael's story is really illuminating in that particular benefit that we're able to bring in our representation for kids, and shows, whether from what Melissa spoke about at the beginning when a hotline call is first made and we're working to preserve a family, up through families that are separated and making sure that they get the best stability, the best support. Legal Aid Chicago is able to help in all of those, and our fight continues.
Great,
Now I'll
thank
turn it
you.
over to Melissa. Sorry, Melissa.
Thank you, Jamie. And so you and Melissa are both such experts on this area of law, and the impact that you make is just astounding. I'm so humbled to work alongside you and grateful to get the opportunity to do so. And we were so thrilled when recently one of our pro bono partners and a sponsor of this webinar series, Catton, stepped up to get involved with us as we were coordinating the amicus brief on the case that you mentioned on the wrongful neglect finding. And we're always so grateful when our pro bono partners flex their skills to join us in a very worthy cause. At Legal Aid Chicago, we have over 20 different pro bono opportunities spanning subject matters and offering everything from a short-term commitment of a couple of hours to a longer-term engagement. And Melissa Stas in particular mentioned a case where we were able to overturn an indicated DCFS finding. And those cases are great opportunities for pro bono attorneys looking for administrative hearing experience on a short time frame. And they present a discrete legal issue and are so impactful for the client. We've got that and several other types of opportunities available. Jamie just mentioned some of the educational outcomes for children and our work related to that. One of our pro bono opportunities is designed to disrupt what is referred to as the school to prison pipeline. Many of the students who are involved in school discipline issues and in the juvenile justice system are youth of color. And our goal in this project is to intervene in 2 distinct ways. We have both a transactional opportunity related to destroying records of juvenile court involvement and hearing experience related to school expulsion and other types of school pushouts. We have comprehensive training available. And if you're looking for those last few hours of CLE before the deadline while getting involved, this would be a great opportunity. You can find more information about all of our volunteer opportunities on our website, and you're welcome to reach out to me with any questions that you have about our opportunities or how you might be able to help. And I'll turn it back over to John Gallo.
Thank you, Melissa P. For those of you who are amazed and confused by all the Melissas we have who are rock stars, Melissa P. and Melissa S., thanks to both of you, and also thanks to Jamie and Darren for those presentations. That concludes our planned content portion of the presentations today. In a moment, we'll start the Q&A. Before we do, a reminder, we would appreciate it if you'd fill out the survey about the presentation. To do that, or if you'd like CLE credit, click on the link in the chat and fill out the form. The certificates of attendance will be sent out to you shortly after today's meeting. It'll probably be a week or so. Please join us next week for our session discussing the needs of veterans. So the panelists are remaining to answer questions, and there are a bunch of questions. I think I already see a big red 13 on the Q&A. So if you have additional questions, type them in the chat. And I'm turning over the responsibility to field those questions to Melissa P. So Melissa P., off you go.
Thank you so much, John. And we do have some great questions coming in, so thanks, everybody. Melissa Stas, this question has come up a couple of times, which is sort of, you mentioned what happens to someone when they are founded by DCFS or there's an indicated report. how long does someone remain on a central registry, or how long does that mark remain with them?
So there is a sort of schedule per statute in the DCFS regulations in terms of the duration of that indicated report. So for most neglect indicated findings, it is going to be 5 years. There can also be 20-year findings, and then 50-year findings. Usually the 50-year findings are for very serious allegations, so severe physical abuse, although just a note, I've represented many parents who have been accused of physical abuse where my assessment is that the evidence simply isn't there and I've been able to prevail. So it can sound scary, but it can actually be a 50-year finding, you know, based on fairly flimsy evidence. But most neglect allegations are going to be 5 years. And then if there's a subsequent indicated finding, then it will, any indicated finding that then exists will remain on until the last in time indicated finding expires as a matter of law.
Thank you. And a related question that's come up, which is, you know, suppose someone after the indicated finding makes changes in their life, including, you know, for example, entering substance abuse treatment. Is there any option to go back and get that finding removed?
Unfortunately not. Their DCFS very strictly applies their deadlines for requesting an appeal of the indicated finding. It needs to be requested in writing within 60 days of the indicated finding. And if you miss that deadline, then it's, you know, sort of a statute of limitations passes. You don't get to seek review of that indicated finding.
Great. Thank you so much, Melissa. And so a couple other questions here related to our connection to social workers. So, you know, when someone comes to us, do we have social workers who get involved in the child protection process? And if so, how do they help?
So I had mentioned for Corinne that we had one of our our supervisory social worker, Janelle Pedroza, who is amazing. She worked directly with Corinne to sort of help her sort through all of the different moving pieces that she had going on. We also have a case recently where our client has a prior DCFS indicated report, and then she was pregnant with twins, and we expected that once the twins were born, the family member that had sort of been behind the prior indicated report would call the hotline again. And in fact, that did happen. And the twins were in a NICU after being born because they were born very prematurely, and our client was staying at the Ronald McDonald House in order to be able to provide care for the twins and see them on a day-to-day basis. And our social worker was able to step in. Once the hotline call was made, the hospital got very, very nervous about, oh, can we let her into the hospital? Can she continue to stay at the Ronald McDonald facilities? And it can be a little bit intimidating and not very helpful for a lawyer to try and intervene at that step. So it can be much more effective to have a social worker then reach out to the hospital social worker to try and alleviate some of those concerns and smooth the waters. So that's another way that we can use our client support services in a way to sort of just provide holistic across the board support for our clients.
Thank you. And we heard from Janelle a whole 7 weeks ago at the beginning of this series on her work with our victims of trafficking and survivors of trafficking. And so if you didn't get a chance to attend that session, I hope that you'll watch the recording to hear more about Janelle's work and how fantastic she is in helping us provide holistic services to our clients. Melissa, there's a couple questions here about sort of, you know, most people are familiar with DCFS at the front end, right? Making a call to the hotline and trying to get DCFS to intervene. And so would you mind talking a little bit about sort of positive things that DCFS can do and when you think it's appropriate to get them involved and how you would do so?
Well, the hotline process itself is a bit of a black box. There's not a lot of transparency in terms of how decisions are made by the hotline dispatchers. But certainly there are cases where professionals working with kids or even someone who is involved in the family's life feels that DCFS intervention is really required. And hopefully DCFS responds. I do think that partly because the system is so overloaded, it makes it difficult for DCFS to respond in a really agile way when it's truly warranted. That's one of the drawbacks of having a system that's so bloated and is so sort of weighed down by all of these claims of neglect that maybe is not actually neglect, but is a family that just needs some extra support. And then the system has a lot of difficulty being able to differentiate its response in terms of devoting its resources truly to those cases where a child's safety is at acute danger. So if DCFS, you feel that they're not responding appropriately, I think probably the best way to address that would be through filing a complaint with the Office of the Inspector General. DCFS does have an Inspector General, which is a separate independent entity that is supposed to sort of oversee the agency, both in terms of ways that it might be overreacting or underreacting, because that's two sides of the same coin. And so, for people who feel that DCFS might be underreacting, certainly a complaint to the Office of the Inspector General would be appropriate. And it's a fairly simple complaint process. It's on their website. Unfortunately, one thing that I wish that DCFS would do better would be to provide those supportive services for families. Unfortunately, the only gateway to DCFS is through a fairly punitive process of investigation and then determination of guilt or innocence. And having everything organized under that sort of framework does sort of set up the entire system to be working against parents instead of with parents. I think that in order to get to a place where DCFS can truly support families and be viewed by families as being a partner, there would have to be a real shift in the way the investigations model works.
Thank you. And you mentioned indicated findings and the ability to sort of challenge that. Do you have any information on the success of parents or other indicated individuals in challenging those findings on their own, that is without an attorney?
I think the vast majority of people who appeal indicated findings do proceed pro se without an attorney. And the last time that I think statistics for outcomes in the administrative hearings, was looked at, this would be interesting information to FOIA, and we haven't done that recently, but it's about a 75% overturn rate. So 75% of the cases that are appealed, it's decided that the indicated finding will be expunged, that there wasn't sufficient evidence to sustain that. And that's largely because the standard to indicate someone is so low, just credible evidence. But then once you get to a hearing, DCFS now has to prove by a preponderance of the evidence.
Great. And Jamie, sort of a question for you, which is, if your client does have your children removed from them, how do you support them after the neglect or abuse case starts in juvenile court?
Yeah, so that's a great question. There's challenges to the legal side of that, because a lot of what needs to happen within the juvenile court process has to do with mandated services that parents need to do. But as we spoke on in the example of Priscilla's story, there's a lot of bureaucratic and administrative pieces that we really help push for and kind of file those motions for unsupervised visits, push the court case to keep it moving forward, find expert witnesses in certain cases. So, we've worked on cases where it's, kind of complicated questions of what exactly happened, and an expert in a particular area may be able to help inform the court and better see what happened. So, it can vary from finding experts to really just being kind of that amplifier of the voice, if you will, with bureaucratic systems that they're just very used to working the way they work. It's a huge court system that has lots of cases. And so things can be really a sludge. And so we can help push the case forward by filing those motions and working with the agency.
Thank you. And there's a question here about sort of monitoring foster care placements. And so, Jamie, I don't know if you can speak a little bit about sort of how we can ensure that once someone is placed with a foster parent or in youth and care, how to make sure that they're receiving quality care.
Sure, that's a great question. So there is, there's caseworkers that are assigned to the family, either through DCFS or actually Darren mentioned the POS term earlier, that's point of service. So DCFS contracts with a lot of other agencies to provide that casework service. So the caseworker is required to have, depending on the type of license of the foster parent, anywhere from like weekly to monthly in-person contact to kind of check on that care. And the caseworker is also responsible as an agent of DCFS to ensure that they're getting their school needs, that their health needs are up to date. There's check-ins on that. It can be challenging, I think, especially, there's a range of placements. A lot of kids might be placed with like a grandparent or a family member, but others are placed with, strangers in communities they don't know, or in shelters when they don't find a placement. A lot of my prior experience is working with teenagers, and teenagers are really hard to place. So a lot of those kids, it is a challenge to make sure that they're really getting what they need. So there are systems in place. They don't always work 100% of the time, but that's probably the biggest mechanism for monitoring foster parents.
And then we've got the question, how long is a child required to remain in foster care? And it sounds like it would depend, but can you elaborate on that?
Yeah, so under federal law, it's supposed to be that after 15 months, the state would move forward with potentially trying to terminate rights. Illinois has interpreted that a little bit differently. And even in cases where states other than Illinois, kids can linger in the foster care system for years upon years, especially kids that are, aren't as adoptable. Like babies are more frequently to be adopted than like a 12-year-old. And so if rights are terminated on an older child, they will often be in the system until they age out, which is actually at 21. So there are kids that spend years in the system, but then there are others that it occasionally is a matter of months. I don't know the statistics off the top of my head. I don't know if Melissa does about average lengths, but it really can vary anywhere from a matter of months to most of the child's life.
And Melissa, a related question for you, which is that, when you're successful at sort of overturning an indicated finding, who makes sure that that finding is no longer showing up on the central registry?
I mean, DCFS is supposed to implement that remedy sort of internally on its own. But when I successfully represent someone and we get the order that the indicated finding is to be expunged, I always send a follow-up letter to the state central register to confirm that it has been removed. And usually it is. There have been a few times where, it's a big agency. There are a lot of automated processes that DCFS is sort of managing and navigating on a day-to-day basis. So there's going to be some error. DCFS is supposed to do it. Usually they do, but I always double check.
Belt and suspenders. I love it. And so we'll make this our last question, which is related to whether or not we have attorneys who can help clients who do not speak English, that is their primary language being Spanish, and whether we could advise on sort of the rights of one parent versus another when the children are involved in the child welfare system. So I don't know, Melissa, Jamie, who wants to give the plug for our services?
Sure, I can. The answer is yes. While we may not have attorneys that always know the language, we do have interpreters both on-site and other interpreting services we can use. So Spanish, we do have some in-house interpreters for Spanish, but we also use an interpreting service for any number of languages. So anyone is welcome and very encouraged to call, and we certainly can advise about how the process works. Whether or not we're able to take a case referral representation, we always at minimum give advice about kind of how the system works and what parents can do within that process.
Great. Well, thank you so much, everybody, for your question, and I'll turn it back over to John to close us up.
Thanks, everyone. Thanks to our great panel and for the questions that were submitted, and to everyone's attendance. We'll see you next week, and we'll be talking about the needs of veterans. Have a great day. Bye.